Good afternoon. Welcome to the Legal 500 Legal Business webinar on what qualifies as acceptance use in Turkey and the EU. I'm delighted to have our sponsors, NSN Law Firm, as part of this webinar session. NSN Law Firm is a leading independent full-service law firm with a special emphasis on intellectual property. NSN has an extensive practice in all areas of IP, including, but not limited to, prosecution, litigation, customs protection, and enforcement services. NSN has been ranked as first tier in rankings of the Legal 500 since 2014 and is also recognized by Chambers and Partners, WTR, Managing IP, IAM Patents, and many others for many years. I'd like this opportunity to now introduce you to our panelists for today's session. Gülay Göksu Önal is a partner at NSN Law Firm and co-chair of both the trademark and the patent departments of the firm. As an attorney at law and a Turkish trademark and patent attorney, she has been practicing IP law for over 10 years. She provides litigation, prosecution services in almost all areas of IP. Simge Şahin is a partner at NSN Law Firm. With her 12 years of experience in IP law, she's managing IP portfolios of her local and global clients from different sectors, both in prosecution and litigation matters. And finally, Camille Vernal is an IP lawyer at Inlex Management Europe and Africa, which is active on both the European since 1995 and the African continent since 2014. After her first experience in South Africa, she's now managing IP portfolios for global clients from different sectors, from the filing strategy to litigation matters. Before the panelists start the session, I just wanted to remind you that we do have a Q&A session that will follow straight after the panel discussion today. If you do have any questions, please do feel free to submit those questions to us directly during the session, and they will be answered by the panelists afterwards. If you have any other further questions after this webinar session, they can be answered and the panelists can be in contact with you afterwards as well. And I'll now pass it over to Gülay Hanım, who will take the proceedings.
Thank you for the introduction, Barış. Hi, everyone. It is lovely to see many practitioners joining us today, and I hope you enjoy with the topics we will discuss today. Let me share my screen first. I think you can see it now. Today we are talking about use requirement, the results of non-use and genuine use in terms of the Turkish and European practice sense. And just a quick note before I get started. While we are covering today's topics, our main goal will be to highlight the issues that may be important for the brand owners to create their enforcement and filing strategies. So we will consider the issues rather from the business perspective, as we want to give practical information as much as possible. Well, I'll start with some background on the use requirement. First of all, in Turkey, the trademark can be registered without the necessity to prove the use or to confirm the intent to use. The use evidence doesn't need to be submitted to renew the trademark registration either. So basically, you can have the trademark registered and enforce your trademark right even if you don't use it. Of course, as it is the case in most countries, this grace period granted to the trademark owners is limited to 5 years. And this 5-year period starts from the registration date, not application date. So if you haven't used the trademark within the 5 years from the registration date, the third parties may have your trademark cancelled. And of course, this is not the only result of non-use. More importantly, even if your trademark is not attacked for not being used and it's still alive, you cannot easily invoke your rights under your trademark. So basically, our entire system is based on the use of trademark to have an effective protection. Now, I want to elaborate a bit more on all of these results of non-use, and I'll first start with the non-use cancellation action. Non-use cancellation actions in Turkey are currently handled by the courts, yet this authority will be transferred to the Turkish Patent Office as from the January 2024. And this authority change is important because I think it will lead some changes in both procedural and fundamental aspects, which may also affect the trademark owners' strategies in protecting their trademarks. I'll mention very briefly the changes that awaits us in a procedural sense, and then my colleague Simge, who will explain the genuine use, will also cover the difference in the genuine use assessment by the Turkish Patent Office and the courts. The most significant impact of the authority change will be that the cancellation proceedings will be concluded in a shorter time, and it will be less costly. And I think this is actually a very good development for the businesses that want to enter the Turkish market and register their trademark, but face some obstacles due to an identical earlier trademark. Because currently the cancellation proceedings are not practical, as they are heard by the courts and they take several years, like 3 or 4 years until the finalization. And this causes many negatives actually. For example, assume that your trademark application is ex officio refused due to an earlier identical trademark. Of course, you have an option to get a consent letter from the earlier trademark holder, but since it is not beneficial from the business perspective, the companies rather prefer filing the non-use cancellation action to get rid of this earlier trademark, to clear the path of their trademark application. However, unfortunately, filing the non-use cancellation action will probably not help you to keep your application alive, because the Turkish Patent Office doesn't wait the outcome of the cancellation action because it takes years. So you will have to wait until the finalization of cancellation action to successfully register your trademark. And due to this unpleasant situation, the companies sometimes prefer getting a consent letter from the earlier trademark holder, which also brings several negatives. First, you have to coexist with an identical trademark. It may not be in use when you get the consent letter, but it can be used later on. And this may lead likelihood of confusion with your trademark. And secondly, the earlier trademark holders in Turkey, in most cases, expect to have some financial gain in return of consent letter. So no matter how you look at it, coexistence is not always advantageous situation. However, I think with the authority change regarding the non-use cancellation action, the companies will not have to prefer the coexistence anymore. because, as I said, the non-use cancellation proceedings will probably take less time, and therefore the Turkish Patent Office will probably wait its results to examine the appeal regarding the ex officio refusal decision regarding the latter trademark. So I also want to mention the effective date of cancellation. The general rule is that the cancellation will be effected as of the filing date of cancellation request. However, if the conditions of cancellation have arisen on a prior date, the cancellation decision can be decided to be effective on such earlier date as well. However, the demandant must have an explicit request for this, and to have the mark be cancelled from the registrar at an earlier date is obviously significant in some cases from the business perspective. For example, again, if your trademark application is ex officio refused, in order to overcome this ex officio refusal decision, the earlier mark has to be cancelled from the date earlier than the filing date of your trademark application. Likewise, if there is an infringement action, you can, of course, overcome the infringement claim by asserting non-use defense. However, it may still be beneficial to cancel the earlier trademark from the date earlier than the date when your accused use is started. And another result of non-use of mark shows up in opposition procedure. Basically, if you base the opposition on your trademark that has been registered at least 5 years before the filing date of trademark application, subject to opposition, the applicant can claim non-use of the mark. And the non-use defense is taken into account by the Turkish Patent Office only with respect to the examination of opposition based on the likelihood of confusion. Other grounds would not be affected by the non-use defense. And if the applicant claims non-use of your mark, your trademark will not get cancelled. However, the likelihood of confusion, the opposition based on the likelihood of confusion will be rejected. And if you prove the use partially for some of goods and services, then your trademark can still be a ground for the refusal. But in this case, the likelihood of confusion will be examined only based on the goods and services on which the use is proven, as it is the case in most countries, actually. And Turkish IP law also allows the defendant in both trademark infringement and invalidation action to claim the non-use of the mark. And here I would like to highlight an important difference regarding the time period for which the use is sought, depending on the type of action. In the infringement action, it is sufficient to prove the use within the 5 years before the filing date of infringement action. However, when it comes to invalidation action, depending on the registration date of grant trademark, there may be a need to prove the use for 2 different times. First, you need to prove the use within the 5 years before the filing date of action, and also if your trademark is registered for at least 5 years before the filing date of trademark, that is subject to invalidation action, you also need to prove the use within the 5 years prior to such date. Here I put an example to make it more clear. As you see, the registration date of the plaintiff's grant trademark is 2011. And so it has been registered at least 5 years before the filing date of trademark subject to invalidation action. Therefore, in this case, the proof of the use within the 5 years before filing the court action will not be sufficient. The plaintiff should also prove the use of its trademark before 2017, which is the filing date of trademark subject to invalidation action. I think the legislator most probably wanted to protect the owners of letter trademarks who obtained the registration, believing that the earlier trademark cannot be an obstacle for them as it has not been used. However, we don't see the same logic in the infringement action, and this may cause some big problems actually. To elaborate a bit on this, I'll give you an example because it is complex to understand. Assume that you wanted to enter the Turkish market, and before doing that, you conducted a similarity search to make sure that your trademark can be registered and your use under this trademark does not infringe the earlier trademark. And as a result of your similarity search, you found a trademark that may pose a risk for your use, but at the same time, you also determined that this earlier trademark is not in use. So you thought that any possible oppositions or infringement claim can be overcome with non-use defense. So you therefore filed the trademark application, got it registered, and started to use it. However, in the meanwhile, the earlier trademark can be started to be used. And well, at this point, a risky situation arises for those who is using the latter trademark, because if the earlier trademark holder files an infringement action, later on, when they become aware of the use of the latter trademark, you will not be able to overcome the infringement claim by asserting the non-use defense, because the plaintiff will then able to prove the use of its trademark within the 5 years before the filing date of infringement action, which is sufficient according to the law. So I think this is a very important point that the businesses needs to consider. Perhaps as a proactive approach, and in order to eliminate any risk in long run, the businesses should consider filing a non-use cancellation action against the trademark that they think that could pose a risk for them. Lastly, I also want to mention very briefly the refiling issue, as this is a very hot topic in recent years, because the trademark owners are considering to refile the trademark that are already registered to get rid of the results of non-use. And I know that the trademark holders are curious about whether and in what cases the refiling is considered legitimate. First of all, I can say that the debates revolving around the repetitive trademarks are actually not very old in Turkey, because The need to prove the use in the opposition and litigation proceedings became possible with the new IP law, which came into force in 2017. The repeated trademarks became a serious problem in Turkey only within the last 5 years. Therefore, I can say that there is no established practice ruling that mere repeated trademarks should be considered as a mark obtained in bad faith. There are few decisions rendered by the courts and Turkish Patent Office ruling the invalidation or cancellation of the repetitive trademarks, yet all of these have own some peculiarities of their own. In example, the repetitive trademarks subjected to these decisions were filed after its owner encountered with the non-use cancellation action against their previous trademark. So I can say that it is not clear yet whether the repeated trademark will be considered as a mark obtained in bad faith if such trademarks are filed without facing the non-use cancellation action regarding the previous mark. Still, to minimize the risk of facing a successful refiling objection in the future, the companies may consider making some amendments to specification of the new trademark applications. However, I think there may still be questions like if there are any plausible commercial logic and objectiveness to register the same trademark with the amended specifications, and like why now? The trademark owner may have to show some reasons to show that they did not file this trademark just because to avoid the results of non-use. And for example, as all you know, several companies are currently getting into NFT technology and filing new applications to use their marks in virtual reality. I think this could be an opportunity for the trademark owners to legitimate their letter applications. So they may consider filing the new trademark applications covering the goods and services related to metaverse, in addition to the current goods and services, which may also be modified in some extent. Also, brand owners modernize their marks over time. For example, by adding distinctive elements or by using a distinctive writing style. So if the aim is to update the previous trademark registration so that the new one more accurately reflects the current use of the mark, even if it is not used in Turkey, this can also be a ground to overcome the bad faith claims, I believe. However, all in all, since the matter is not yet well established by the courts, it is difficult to estimate when the refiling is considered in bad faith, I can say. So this was the end of from my side, and if you have any questions, we will be happy to reply them. Now it is now Simge's turn. Thank you.
Thank you, Gülay. It was very clear and helpful representation. Now I'm sharing my screen. Okay, now I think. Hello everyone, thanks for your attendance to our webinar. In this section of our webinar, we will talk about what constitutes genuine use as per the Turkish IP law. Our main goal with this topic is to make it more clear before the trademark holder's mind what constitutes, what type of uses constitute genuine use, or what type of uses are accepted as a token use, and what kind of evidences should be submitted for the proof of genuine use, both before IP courts and Turkish Patent Office, because as we will be explained in this section, there are some differences in the evaluation of IP courts and Turkish Patent Office on the evidences. Let's talk about law text firstly. There are two essential articles in the IP law regarding non-use cancellation of a registered trademark. Both articles refers to the requirement of genuine use in order to avoid non-use cancellation of a trademark. So we easily understand that the sole proof of use of a registered trademark with few evidences is not sufficient. The trademark holder needs to show real intention to use the trademark to take a place in the market. Also, Article 26 to 4 of Turkish IP law regulates that the uses within last 3 months prior to the non-use cancellation action date are not taken into consideration. But what if the users go back to last 3 months? And what should we understand from genuine use? And what are the criteria of the genuine use during the evaluation? There is no definition in the law, but in the doctrine, the commonly used definition is that the use should be performed as to benefit from the functions of the trademark. That is to say, the trademark should be used in the market as to distinguish the goods and services provided under such trademark from the others ones, and enable such goods and services to be recognized in the market. Also, although there has been almost 20 years, IP courts and Turkish Patent Office always refer to the European Court of Justice definition in its decision, Ajax decision, dated 2003. In that definition, European Court of Justice states that if the mark is used in accordance with its essential function, which is to guarantee the identity of the origin of the registered goods or services, in order to create or preserve a market for those goods or services, such use constitutes genuine use. So, as we understand from both definitions, the trademark should be used with real commercial purpose to have a place in the market. And during the evaluation of genuine use, there are some criteria applied by IP courts and also, of course, the Turkish Patent Institute. These criteria are the volume of the use, the nature of the goods or services at issue, geographic area where the use is performed, the characteristics of the market, the scale and frequency of the use of the mark. For example, lesser amount of sales can be sufficient for luxury goods. For example, 2 or 3 sales of Rolls-Royce branded cars in a year may be sufficient for accepting its genuine use. On the other hand, the higher amount of sales should be sought for fast consumption products. For example, tens of thousands sale of chocolate products are sought for accepting genuine use. So each factors are evaluated in the conditions of each case. Genuine use, it's clear that token use is not a genuine use. Use of a trademark that are purely for the purpose of securing a trademark registration without any true interest of making commercial sales are accepted as token use. The expected behavior from the trademark holder is to use the trademark regularly and continuously as to create and save a market share without creating any doubt. So we need to check what type of uses are not accepted as genuine use, so they are accepted as token use in the practice. I here share some examples, both they are all taken from IP courts or Supreme Court's decisions, their evaluations. Production and sales on a very small scale and symbolically. Printing and distributing calendars, brochures, catalogs in small numbers and along with small size of sale. Use of a sign as a trade name at invoices or other commercial documents other than use of a trademark. Is a really basic sample in we came across at court actions, because the trademark holders always provide invoices, but those invoices only bear the trade name in a standard written form, and the main element of the trade name is not written in a bigger font, so the courts do not accept such uses as a trademark use. And use of a trademark for a very limited period is not accepted as a genuine use. And mere granting a license right to a third party who does not use the mark is not accepted as genuine use. Other from these examples, I can share some examples too. For example, the use of a trademark on a warranty certificate or user guide or Turkish Standard Institute certificate are not taken into consideration as a genuine use, as a proof of genuine use, because they do not show that those goods reach to the Turkish consumers. They do not prove the actual use. Istanbul First Anatolian Intellectual Property Court rendered a landmark decision in last years. It's about, of course, no-use cancellation of a trademark, and the court deeply evaluated the time period of the use in order to understand whether such uses constitute genuine use or not. In the subject matter, the trademark was used for 6 months period between June and October 2017. And then the trademark became vulnerable to non-use actions on October 2017. And after that, only limited uses were performed, we may say non-use. And on April 2018, we filed a non-use cancellation action against such trademark. Actually, the trademark holder submitted invoices showing the sales of DVD products in a considerable volume to prove the use, and the period was 6 months. Not the use were not performed within last 3 months prior to the action date. But we insisted and highlighted that such uses are token uses because they were performed just before the vulnerability date of the trademark, and only for 6 periods. The trademark holder did not continue its uses after the vulnerability date. They show some uses, some few invoices after the vulnerability date, but we always thought that those uses were related to the products that are sold from the stocks, but no new products were produced or sold by the trademark holder, showing that the trademark holder does not have any real commercial goal to use the trademark, to have a market share, to take a place at the relevant market. And the court will make the deep evaluation. The court reviewed the case in detail and decided to the non-use cancellation of the trademark even for DVD products, because there were in a considerable amount of sales for DVD products. But the court took our arguments into consideration and stated that the sales of DVD products occurred in a certain and limited time period, and such period was close to the vulnerability date. The trademark holder did not continue its uses later on, and those sales would be deemed as token use in order to prevent the cancellation of the trademark. It's very important decision in our law because not only amount of sales, but only use period. Also, use period is very important to understand whether the uses were performed in order to avoid non-use cancellation or really take a marketplace in the relevant market. And as I said, Turkish IP courts and Turkish Patent Office have some differences, important differences in the evaluation of evidences, use evidences. Unlike IP courts, Turkish Patent Office specifically requires the submission of invoices. Actually, it's not mandatory at our law. The use can be proved with other strong evidences, bearing the trademark end date and showing that the trademark was put in Turkish market and reached to the Turkish consumers. But in recent decisions, in recent files, we see that Turkish Patent Office strictly requires for submission of invoices, and even if you submit any other additional strong evidences, they insist on the submission of invoices. Turkish Patent Office also requires proof of the link between the trademark holder and another entity which carries out the trade activities. It's important because there are so many global and group companies, and in the structure of group companies, the company who holds the IP rights of the group companies and the company who carries out the trade activities are different entities. And of course, in that scenario, the invoices or other commercial documents, use evidences, bear the name of operating company, not the trademark holder company. When it comes to evaluation of Turkish Patent Office, they require that the evidences should bear the name of the trademark holder. We explained several times during our conversation with examiners, during our meetings with them, about the structure of group companies, and it's very usual that the holder company and operating company are different, but they require for the submission of trade registry documents showing the administrative link between the companies. But sometimes it cannot be submitted from the trade registry. And in such cases, we always recommend our clients to provide at least an authorization letter given by trademark holder where it declares that the operating company has the authorization of the trademark holder company. We submitted in different cases such letter to TPO and it's accepted. So we always recommend global group companies to hold these evidences from very beginning and when submitting the use evidences. Also, Turkish Patent Office does not make a proper examination on whether the uses are genuine use or token use if the above requirements are met. As I said, they require for invoices, they require to see the link between the holder company and operating company. And if all these are in order, Turkish Patent Office examiners do not make a detailed examination as IP course. To understand whether the uses are genuine uses or whether the uses are token uses. But when it comes to IP courts, they have a broader interpretation on any evidence. Of course, it's more easier to convince the IP court about the link. Or if you don't have enough invoices, you can support your evidences with other evidences such as catalogs, user comments, social media sharings, any evidence showing the use of a trademark in Turkish market. But when it comes to evaluate if the users are genuine users or token users, the IP courts make a detailed examination, as we shared the Istanbul Anatolian IP Court's decision. So, lastly, I would like to take your attention to some important point in our country. As you may also know, in the last years, there has been a big immigration from Middle East countries to our country. And immigrant people mostly reside in certain regions in our country. We know from our global clients that they have some special brands targeting the Middle East countries, targeting the consumers consist of Arabic people. They have special brands for that. And after the immigration, infringers started to imitate those brands. Because now we have a big population of Arabic people in our country, and they try to sell those imitation products to those people. When it comes to enforce the trademark rights in Turkey against those infringers, our clients face with non-use cancellation or non-use defense risks because they do not use such trademark in Turkey. They use those trademarks in Middle East countries. And we recommend that now those people are in our country, and if you target those people, you can also launch your trademark branded products, and you can sell those goods to Arabic people in our country. And in that option, of course, not one or two batch of sales will not be enough, but rather than targeting all area of Turkey, such as other brands targeting whole public, you may sell your products in certain regions where Arabic people live. And of course, your sales should be regular, your use should be regular, not only one or two batch in a year. But if you send regularly your products to Turkey and sell them, then we may challenge that before IP courts that your trademark or Turkish Patent Office, your trademark is in use also in Turkey. I hope this presentation made Turkish practice more clear on your mind, and I hope you enjoy it. Thank you very much for your attention and listening. Now, dear Camille will talk about European practice for us. Camille, now it's your turn.
Thank you very much. And yes, thank you to both of you for enlightening us on the Turkish practice. So I will now share my screen first. Wait. Okay, so it should be on your screens. Wait, I'm gonna put it on the... Okay, so I will now focus on the European Union perspective, which is kind of similar to the Turkish practice. So I will maybe briefly come back on the basics of the requirements and the calculation of delays, because it's always kind of a problem or an issue when it comes to practitioners and businesses. I will then talk briefly on come back to the criteria for genuine use, and I will focus more on the practical examples because I think it will be more efficient, and I will also talk a bit of the repetitive and bad faith trademark issue at the end. So regarding the use requirement in the EU, so as for the Turkish law, trademarks are vulnerable to non-use cancellation if they are not used, genuinely used for a continuous period of 5 years. And it is possible to require partial revocation. So if only some of the goods or services are being used under the brand, they can continue, stay valid and not the others. And there is only one exception to that principle, is that if the owner of the trademark has a proper reason for not using or genuinely using the trademark, but it must be beyond its controls. For example, when it comes to pharmaceutical companies, for example, where they have to wait for an authorization to put on the market their product, it could qualify as a proper reason not to have genuinely used the trademark. So it's really just an exception. Regarding the calculation of the delay, so when it comes to European trademarks, it's pretty easy because you start counting from the registration date, which is on the register page displayed. So it's kind of easy. And the relevant period will be those 5 years from the registration date or prior to the institution of the action for cancellation. Bearing in mind that the 3 months preceding the institution of the action is called a suspect period because and the use made during that period will be irrelevant for the action because the trademark owner became aware of the action. So it's a period of time that is more for negotiating and trying to comply with or talk to the other side and see if a solution can be reached, rather than putting the trademark on the market last minute. And then for international trademarks, the beginning of the 5-year delay will be either the date of the publication of the statement of grant, when there is one, and if the office does not deliver one, it will be at the expiration of the 18 months delay for the EU IP office to notify its decision. So either a statement of grant or provisional refusal. But in most cases, there will be a statement of grant, so it makes things easier. So as for the criteria for genuine use assessment, so it's basically the same as in Turkey. So I will just briefly come back to each of them. So regarding the place of use, what is different in the EU is that there is 27 member states, so it's a bit different. So for a use to be considered genuine, it must be used in a substantial part of the EU. So it does not mean that it must be used in all of the member states, of all of the 27 member states, but in a substantial part. So it leaves a bit of interpretation about the substantiality. Like, for example, for some cases, which must really be regarded as an exception, use in only one EU member state was considered enough or sufficient to prove genuine use. It really depends on the sector and the type of use that is being made and the product and services. And regarding the Brexit, because it has been, of course, it has impacted the trademark law and practices. So regarding the assessment of genuine use and the Brexit, there is no retroactive consequences, which means that if a trademark owner is required to show genuine use in the EU before the date of the Brexit, so December 31, 2020, it will count, use in the UK will count as genuine use of the European trademark. Past that delay, of course, the trademark owner would have a UK trademark and it will not count as use. So if you have a European trademark and only use it in the UK in the past, it is very important to now start putting in the market on the European market. Otherwise, it shall not count as genuine use. So the author of the use, of course, it would be the owner of the trademark, which can be a natural legal person, but it can also be an authorized user. So we think obviously of licensee and sub-licensees if they are authorized in the license agreement. But some cases also have considered distributors of the owner of the trademark to be considered as authorized user and therefore to be considered as the owner themselves. So it's easier when there's a contract, of course, a license agreement or a distributor agreement, but the European Trademark Office has shown some practical behavior to consider use as genuine and to consider the distributors, for example, as authorized users. In the same line, they have considered, for example, a company belonging to the same group as the owner of the trademark to be also considered as the owner themselves. So, of course, affiliation has to be proven, but it's a very practical interpretation. And the burden of proof of the link between the user and the trademark owner lies with the owner of the trademark, which makes sense because if a use is unauthorized, then the owner wouldn't have any proof to submit to the court. Regarding the product and services used, so the principle is that for it to be genuine, a use must be done in relation to the goods and services for which it has been registered. So it's very important to understand that even though a category of goods or services has been designated under the trademark and that is broad, the trademark owner will have to demonstrate use for each and every goods and services within the specification. So with that in mind, it is possible for partial cancellation. So if the trademark is only used for a part of the goods and services, and then it leaves it impacts also the opposition proceedings or infringement actions, because then the mark will be revoked only for those products or services. There is no exception for well-known trademark, because we know that sometimes for well-known trademarks, they can have a protection beyond the goods and services for which they are registered. It does not apply here. So here it's very strict. You'll have to prove use of the mark for the product and services designated. So for example, when there is specific use, I've taken the example of electric cars, for example, or racing cars. Those would be considered as autonomous from the broader category of cars. So if the trademark owner shows use in relation to racing cars because of their different nature and characteristic, it would not be considered as genuine use for cars or as the broader category. So it's important to keep that in mind. And on the other end, for specific goods that are for which the criteria of the market segment or the geographic origin, these criteria would not be taken into account when it comes to this assessment. For example, luxury cars or luxury clothing would be considered as similar or as similar to cars or clothing. So if you show use for luxury cars, it counts as use for cars. Same with the wines with different appellation of origin. If you show use for one appellation, it demonstrates use for wines, the broader category. And there is only one exception to that principle, is for spare parts and after-sales services. Because even though they're not the goods and services as registered, they would be considered, use for those goods and services would be considered as genuine because they have a particular link to the product themselves. Regarding the sign use, it's often a question that comes from the trademark owners. So use of the sign to be genuine must be done as registered. That's the principle. So the evidence must show that the challenge mark is used, first of all, as a trademark and not as a trade name or merely as a corporate name, for example, and it must be done as registered. However, if there is an alteration to the trademark that is that does not alter the distinctive character, then it is still considered as genuine. So the thing to understand here is that there are dominant and distinctive parts in a trademark, and if those parts do not change, even though the peripheral elements are changed, it does qualify as genuine use. We'll come to that when I'll talk about the practical examples. It will be clearer. Regarding the extent of use, so as I said, use does not have to be done in all of the European territory, but it must be real and serious, which means that it must be done as a trademark, so in conformity with the essential function of the trademark. And it must be done not only for promotional purposes or as a promotion, but really as an attempt to win some market shares or to maintain them, and to demonstrate that there is actually a use with a link with the end consumers. So like there is a real turnover on the for this trademark. And on this topic, like the others, it's always a case-by-case approach. So every sectors will be taken into account. Like you said, Simche, if there is a use for in the food industry, for example, you will wait more use and more turnover than for racing cars, for example, or for luxury cars. So it's the extent will really consider the characteristic of the case at hand. And then to finalize, there's a global appreciation of all those criteria. So the court will take into account the interdependence of all those criteria and assess the use globally and on a case-by-case basis. So it's always difficult to advise a client at first, because it's always done globally and depending on the circumstances. So the overall assessment of the evidence must be based on all the factors and circumstances capable of establishing the reality of the commercial exploitation, and to show that it really targets end consumers on the market. Meaningful use can be established by a combination of elements that taken individually would be seen as insufficient. So if there is use only in one state, but that this use reflects on all of the other states, then it can be accepted as genuine use. It cannot be demonstrated by probabilities or presumptions. So like I said, it has to be shown as a concrete and objective element of use, for example, invoices, turnover, etc. And a low volume of product markets under brand name may, for example, be compensated by a high intensity or consistency of use through time, and vice versa. So now let me show you some example of cases that we have seen recently in the EU. So for example, it has been considered that the import-export of products can qualify as genuine use. So for example, in the first case, it was a use from the export to single operator located outside Europe, was qualified as genuine use, even though the trademark was not used on the European market, but for export outside the EU. And on the second one, it was used, the sales were done in Austria and Great Britain from the Netherlands, and it was still considered as genuine use in the Netherlands because it was export from that country. Now, when it comes to the sign used on the market versus the sign as registered, so you can see clearly how the courts react. So for example, when the trademark is registered as a verbal element and used within a more complex trademark as a logo, it is considered as genuine use, because obviously the dominant and distinctive element is that verbal element, and we find it in the logo that, itself. So it does qualify as genuine. Same here with the trademark Diacol Portugal. We can see that Diacol, which is the dominant part of the mark, is being used, but not the term Portugal, which is actually descriptive of the origin of the product. So this modification does not alter the distinctive element, the distinctive character of the sign. So it does qualify as genuine use as well, if we just focus on the signs. Same here. So here you can see that it's a bit different because the color has changed, the disposition, and even the style of the letters, but it's still considered as genuine because all the distinctive and dominant element as registered are also used in the market. So this figurative element is still part of the mark as used. The three letters BUS as well. And the phrase underneath is only a description of the company. So the fact that it's not being used with that phrase does not alter the distinctive character of the mark. So it's still relevant. And finally, with this one, same here, we have a verbal trademark registered that is used within a complex logo. These elements, the first phrase is only descriptive, so it does not alter the distinctive character of the mark as registered because it is descriptive. And same with the figurative element. It's not the dominant part of the mark because the consumers will more remember the verbal part. So it's still considered use as registered. On the other end, for example of use where the trademark or the distinctive character has been altered, you can see this example, Love Young and Young Love. You can see that the fact that the two terms have been exchanged shows that the conceptual meaning or the meaning of the mark changed, and so the distinctive character was altered in this case. And here, it's the fact that even though we can find the two letters N within the logo, the fact that Nunez Navarro had been added to the sign alter the distinctive character because they add some very distinctive element to the two letters N. So that addition makes the whole sign different because they have their own distinctive character. Then briefly on the rule that says that the trademark must be used in relation to the specific products and services for which it has been registered. You can see that, for example, footwear, a use of the trademark in relation to retail of footwear has been considered not acceptable because the trademark registered for footwear individually. So it has been considered different. And same for all these services. For example, in this case, use for entertainment services was not taken into account in assessing the genuine use for education services. So it must really be like when it comes to filing a trademark, it must the list and specification of goods and services must be drawn specifically to the needs of the company, and trademark owners should not designate broad categories without really thinking of the actual use they're going to make, because they could lose their trademark because of a poor specification of goods and services. When it comes to the elements that can be submitted to show the genuine use of trademarks, contrary to the Turkish approach, even though it's very similar, but the European IP court will not require invoices. However, they do. It's the most efficient way to show use of trademark, because there is a date, territory, and an extent of use. So it's really the easiest way to show use, but it's not the only way, and it can be shown differently without submitting invoices. Like, for example, in those cases, showing combination of invoices, brochures, press clip, and price list, for example, qualified as genuine use. And And in the last case, for example, we can see that only one single invoice was submitted. However, the extent of use on this shown on this invoice, and the fact that it was submitted in combination with labels of the products and other proof of use, was considered sufficient, even for the whole European territory. So it really depends on the case, the products, and the sector within which the trademark owner operates. And yeah, it can, like a poor number of invoice can be sufficient if there are other elements submitted, like a turnover or any element showing actual use on the market. On the other hand, I would like to talk briefly on a case that is recent and that shows that proof of use must be really considered as very important to maintain a trademark and not to submit poor evidence. In 2019, McDonald's actually lost their trademark filed in 1996, Big Mac, in a revocation cancellation action against Supermax, because they did not succeed to demonstrate genuine use. So they had provided 4 types of evidence, which was affidavits signed by the representative of McDonald's, brochures and advertising poster prints in German, French, and English, numerous prints of websites registered with the domain names under several extensions in relation to EU countries, and a printout of the Wikipedia website providing information on the Big Mac burger. So because of the well-known and the reputation of this trademark, I think they believed it couldn't be revoked. But because they didn't actually show use of the mark on the market with turnover, with invoices, which shows really actual and serious use, they actually lost their trademark. So the link with the end consumers must really be drawn to the court's attention. So it was the same here, where the proof of use were considered irrelevant. So, for example, photographs of footwear or declaration affidavits are not sufficient. Catalog as well and magazine extracts are not sufficient because they do not show that end consumers really got the products or services at hand. And then to end of my presentation, I would like to talk about the repetitive filings and the bad faith issue with an example. So recently as well, there's been a case where Monopoly were involved. So it was an opposition against from Hasbro, the trademark owner of Monopoly, against the trademark application for Drinkopoly. And following that opposition, the owner of Drinkopoly filed a revocation action against the Monopoly trademark because they considered that Hasbro had refiled the same mark over time in order to avoid facing use requirements. So they actually filed 3 trademarks in relation to different classes between 1996 and 2010. And in 2010, they refiled a new application from the trademark Monopoly in relation to all of these classes. And they added only a few goods and services, which were different to the previous one. But most of the goods and services were the same as the one in relation to which the previous application were filed or registered. And the Board of Appeal of the European Court decided that it was actually filed in bad faith because they actually recognized that being able to rely upon one registration without the need to prove use was a benefit to them. So it was one of the reasons they actually applied for the forced trademark application, even though they had also other explanation and relied also on the fact that most businesses wants to do that or actually do that. And the fact that the refiling is not solely motivated by the advantage of not having to prove the genuine use of the mark concern, but on other reason as well, does not make this strategy legal and acceptable according to the European Court, nor does the fact that other companies use the same filing strategy. And as such, Hasbro's latest monopoly trademark registration was declared invalid for all the goods and services they had been covered. And so, of course, it has impacted the opposition action, because then the basis of the application of the opposition was now declared invalid. So the whole strategy of Hasbro felt at this point. So it's very important to respect the law and the aim of the policy of or the trademark laws, which is to protect each competitors and to use the trademark in a market, and not to extend those rights by trying to file repetitive filings. And that was all for me. So now if you have any question on all of our presentation, we'll be happy to respond. I think there's actually already a question regarding the holding structures and the fact that subsidiary using the trademark, although it is registered in the name of the holding, does qualify as genuine use. So in the EU, it would be considered as genuine use or used by the owner of the trademark. And I think Turkey as well, under your control?
Yes, Kevin, it's similar in our country. If the subsidiary of the holding company is using the trademark, it can be accepted as the use of holding company who holds the IP rights. And in our country, written license agreement is not mandatory for proving that the uses occurred by the authorization of the trademark holder. As I explained in my section, we always recommend to prove the link by submitting trade registry records, or a simple authorization letter would be very helpful to convince the TPO and also IP courts. No need to, it's not mandatory to submit written license agreement.
Yes, it is the same in the EU. Recording the license agreement is not mandatory as well.
Yes. I think we have another question. Is asking if the use of a trademark with other additional elements is accepted as the genuine use, is the use of the registered trademark. I think it's very similar in our country to your very helpful examples. When I listen you, I thought that it's very similar in our country as well. The Article 9 of IP law allows the use of a trademark with other elements, provided that the distinctive character of those that trademark is not changed. As your examples, you can use the black and white trademark with colorful version, or you can add non-distinctive elements, word elements, or you cannot use non-distinctive element at the registration, but you need to use the distinctive element in any case, of course. Or if you add some additional and distinctive character, then we may say that the distinctive character is now changed and it's not the use of the registered trademark. It really depends on the circumstances of each cases.
And there is another question that concerns my part, I think. It says, when the Turkish Patent Office starts to handle the revocation proceeding based on the non-use, will it be possible to file a lawsuit for the cancellation of office's decision ruling the cancellation of trademark? if it is possible, how this will affect the businesses who want to register their trademark as soon as possible. Well, yes, the trademark owner whose trademark is cancelled due to non-use by the Turkish Patent Office will have a right to file a court action for the cancellation of such decision before the Ankara IP courts. However, I think if the trademark owner cannot submit any use, I think their cancellation action will be dismissed because they are bound with the evidence that they submitted during the opposition procedure, cancellation procedure. So I think they will not have any motivation to proceed with such costly court action. That's why filing the cancellation action before the Turkish Patent Office will still be practical, I think.
Yes, I think we don't have another question, right?
Yes, I don't
Yes.
see.
Okay, so dear Gülay and dear Camille, thank you for your very, very helpful and clear presentations. I really enjoyed it, and I'm really pleased to have this webinar with both of you. And thank you to all of our participants for their time and attendance to this webinar. If you have any other questions after this webinar, you can send an email to us. Thank you all.